Yes, we're here on this clock. He has a motion to revoke.
Yes, Your Honor. I can let counsel lead the way if you'd like, counsel, but I believe, especially while we're kind of off the record to begin with, this is their client's third MTR. And I know that counsel, again, if I don't want to misstate anything, but I know you had previously put forth a motion to reduce bonds, or I apologize, for early term.
Right.
So if you want to maybe just let the judge know what was maybe previously discussed.
Your Honor, would make clear to the state that the state had been given a CD with his medical records in the last 2 years. During those 2 years, he's amassed 1,200 pages of medical issues and problems. How many times have you been in the hospital for working already?
8 times and about 15 surgeries.
15.
Yeah, and then I had a stroke.
He also had a stroke that affected his physical capacity. Mr. Klein has tried very hard to live up to 100% of his requirements, and he's not been able to because of, I'd say 90% or more, because of his medical conditions. He lost his left foot in an accident, and he's now asking the court under mercy, if there's not anything else, to let him stop the probation supervision. Robert, do you want me to swear him, Judge?
Oh, well, just a second. So I'll let you swear him in if you want to have him give testimony. It's my understanding that he does have the medical issues. The court is aware of your medical issues, but here's the court's problem. One, I'm not going to consider early term or anything without the complainant being present. Number two, in the stipulations, the allegations that were in it that were stipulated to was that he went to her father's home, burned the grass with, it says here, the complainant provided her statement to me, because I see you're curious about what I'm reading. The statement can be located in the case folder. In her statement, the complainant describes her relationship with the suspect and described his escalating behavior, which included burning her father's front yard with gasoline and spelling the word BITCH with said gasoline. She also reported how her vehicle was tampered with. The decision to obtain the warrant came after I returned the following week to work and received a message from the complainant that the suspect had went to her work and was observed placing tacks under the complainant's tires. I also obtained a statement from the complainant's boss. The complainant provided several case numbers which document suspect's behavior. So I'm not going to consider allowing him to early term until the complainant is here to express whether or not she has any objections to early termination. And I'm also not going to consider early term because I realize that there are medical issues that may have occurred, but according to the motion to enter adjudication of guilt, there's a non-reporting in September, October, and November 2023. There's the consuming of alcoholic beverages. I'm not taking any of this is true, but it's alleged. On March 9, 2023, on the 22nd of March, 2023, an invalid sample for drug testing. April 6, 2023, another invalid sample for drug testing. May 19, 2023, invalid sample. June 23rd, 2023, invalid sample. And then there's a number 5, not reporting July and August of 2023. And I know that maybe that's medical. 9A, not reporting a change of address, job, or arrest within 48 hours. Then there's number 23, failure to complete intensive outpatient drug and alcohol treatment. And number 24, violation of the zero tolerance. So I'm not inclined to grant an early termination if the complainant is not present by Zoom, if nobody objects to Zoom, to give some input to the court.
Well, and Your Honor, just to make clear, council and I have spoken, and of course, the state is sympathetic to, when things happen to people of a medical nature. But the state did let council know that given the frequency of the MTRs in and of themselves, I believe this is the third,
Yes.
and the term of probation is due at the end, before the end of the year. The state would kind of respectfully not, be in agreement with council for an early term as well.
Okay. So, the court is not going to consider an early termination without that information. What we can do is, if he wants to enter pleas to the motion to revoke, he can enter pleas today, or either we can set it for a contested hearing. And I realize that it may or may not be a contested hearing. We'll just set it for a contested hearing. That'll give a chance for parties to bring in whatever information you all want the court to consider.
I don't think I'm speaking out of turn. Would the court consider, I don't know if the statement, statement from the state, if they would consider a termination unchecked, would you go on with medical care and stuff, if it still does the work?
Now, I want to hear from the complainant. Yes.
When's the last time you did that?
Oh, well, I'm sure the state has their contact information.
I mean, she doesn't know how much.
You want to give us a date? Joe?
Yes. All right, if you all want. Norma, are we able to bring this back on the 22nd or either in March?
March 5th.
The foodie's already.
Oh, well, look, we're setting on the day he lost his leg and on the day of your daughters, your twins.
Birthday on March the 5th, that's a good day.
All right, so March 5th?
Well, Judge, may I ask one clarification question?
Yes.
Sometimes, and of course, it's nothing to do with the party standing before you. In general terms, as the state, I may not give information, contact information, phone numbers of complainants, particularly those that have, been cooperative with the office in the past, and of course, sought prosecution for the things that have happened to them. I'm more than happy, of course, to reach out to them. It's been a few years since we've had that contact. But if they indicate to me that same kind of willingness to cooperate and that same kind of almost happiness to kind of maybe not have anything to do with, the specific party, is it okay to relay that to counsel without sharing that information? Because I don't want to, I want to be as helpful as possible to the court and to counsel, but if she's still cooperative, I would maybe, I think, just be hesitant to relay any contact information over.
Oh, no, just have the person on March 5th. Defense, will you have any objection if they want to zoom in?
That's good. I'm certain that, Mr. Bryan has had no contact with the baby, will not, and I will not provide him any information or means by which he would have.
Oh, I know you would not.
And even if the state, Your Honor, is still, if that complainant potentially, it's been so many years since we've spoken to her, but if they themselves have very strong thoughts on early term, and it may not be exactly what we anticipate, her testifying via Zoom or speaking to the court via Zoom is just
Just have her come in by Zoom, and then we will see what she says.
what she said. Okay,
Yes.
Judge, thank you.
All right, you're
Appreciate it.
welcome.
And just for the record, trying to understand that you are not to have any kind of contact, direct or indirect, with police. You're not sending that contact with her or any-
Month before I got, the one. We get over to you, almost.
Okay.
Thank you, Judge.
All right, you're welcome, Ms. Ferguson. Yes, Ms. Ferguson will give you a reset form that you can be excused. You're welcome. Thank you for coming down. Court is calling 2023 CR 8667, State of Texas versus Leonardo Carlos. Can I have parties announced for the record for the state?
Daniel Escobar.
Defense,
George Sherman on behalf of Ms. Carlos.
are you Mr. Carlos? Counsel, have you received all the discovery? Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery, showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it?
Yes,
Did you
sir.
sign it?
Sure.
Did you understand you're charged with driving while intoxicated, third or more? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine.
Sure.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Sure.
According to the plea, punishment is to be assessed at 5 years in the prison. There's a $500 fine. State recommends community supervision. This will run concurrent with County Court Cause number 710098, 71099, taking consideration 2023 CR 6643, County Court Cause number 713955, 713958, ignition interlock for half the term, victim impact panel, and DWI intervention. Did you understand that to be your plea?
Sure.
Defense, is that the plea?
The plea includes an option of either 10 years jail, 10 days jail.
That's outside the plea bargain agreement.
It's in our plea bargain.
No, it's outside.
It is part of our plea bargain.
What I'm telling you, counsel, is this is your plea bargain agreement. This is outside the agreement.
Well, it is my understanding it's part of our plea bargain.
All right, it is, I'm telling everybody, it's not a part of the plea bargain agreement. Note, this is what it reads. Note, the parties are not allowed to make binding agreements regarding the length of community supervision or the terms and condition of community supervision, which are totally dependent upon the court's discretion. The following recommendations do not constitute part of the formal plea bargain agreement. However, the state or both parties make the following non-binding recommendations. And what it says is 5 years community supervision, TAP evaluation, 120 hours of community service restitutions, 2-year driver's license suspension, 10 days house arrest in lieu of 10 days Bear County jail. That's not a part of your plea bargain agreement. You all can present that to me and I can either follow it or not follow it, but that's not a part of the plea.
Is the 5 years probation part of our?
No, it is not. The court
So-
determines the length of a probation.
And if you reject that 5 years, then it's a rejection of the plea bargain agreement.
No, if I don't follow your length or your suggestion for the length of probation and I give you, let's say I were to give you 8 years on probation or 4 years on probation, that's not a part of your plea bargain agreement and I have not violated your plea bargain agreement because the court determines the length of probation, not attorneys.
Then Judge, I think we can't go forward with this because our understanding of what a plea bargain agreement differs.
All right, well, what I'm telling you all, according to the law, you cannot come before the court and tell the court, I want to be on probation for 5 years only. Y'all are not allowed to enter that agreement, period.
Now, Judge, you do not have to follow that agreement. That is correct.
That is not a part of your plea bargain agreement, counsel. The court decides the length of probation that somebody is on. The attorneys do not. The attorneys just make a suggestion. I'm going to read it again. Note, the parties are not allowed to make binding agreements regarding the length of community supervision or the terms and conditions of community supervision, which are totally dependent upon the court's discretion. The following recommendations do not constitute part of the formal plea bargain agreement.
Is probation
then-
part of the agreement?
Yes, they're recommending probation. Now, if, for example, if I were to say, okay, you guys have agreed that he's to have probation and I say I'm not giving you probation, then I will have violated your plea bargain agreement. But the length of time, the conditions, that's completely up to me. You all can't enter into a plea bargain agreement telling the court what your conditions will be.
That is not my understanding of the practice in this county.
Well, if people are practicing that different in this county, and I don't want to be mean to anybody, but if people are practicing that differently, then they are practicing the law incorrectly because the court decides the length of probation. Nobody else does. Defense attorneys don't decide the length of probation. The state doesn't decide the length of probation. The court does. Nobody else does.
Well, I guess my concern is moot at this point unless you do not follow our agreement.
Well, the question becomes, what do y'all think you have agreed to? Because if you think you've agreed to how long he's going to be on probation, that's not a part of your agreement. So if you all want to reread your contract, you're more than welcome to reread the contract. If you all want to go forward, you can go forward.
Well, Judge, I guess I need to review that comment
Sure.
and we'll come back to it.
All right. And state if you want to show him.
Words based on the court's understanding.
No, based upon the law, councils do not get to determine the length of probation or the conditions of probation. That's not my understanding. That's the law. If people want to get that law changed, they need to talk to the legislature.
It's been my understanding and the practice in this county that the judges allow us to do that.
Well, I don't want to disparage any judge, but guess what? They're wrong. Because according to the law, according to that document that y'all just signed, the court determines the length of probation. Nobody else determines the length of probation. The court does. So if the state is asking for 8 years probation as the length, I can say, you know what? I've read the facts of this case. I think the person should only be on probation for 4 years or 3 years. That's up to me. Or the state may say, me and the defense counsel believe the person should be on probation for 5 years. I may read it and think, no, that person should be on probation for more than 5 years. I'm allowed to do that. And guess what? That is not going against the plea bargain agreement that you've entered to. So if y'all want to discuss that, you can. But if other judges are saying, oh, the law is that's the plea bargain agreement, then those judges would be wrong. All right. Yes.
I'm not ready to go forward with it then.
Then we'll be in jury trial. All right. Macy Malone.
Present.
All right. So did they give you, and if you want to hand that back. So jury trial is at 1:30. And you can put that in here. All right.
Well,
Macy.
we're announcing not ready on the trial because we were expecting
Oh, you all need to file a motion. I'll hear it and make a ruling on it.
Okay.
All right, Macy Malone.